Do not buy 12 Tribes on Earth hair growth oil and hair magic elixir unless you want super healthy, gorgeous hair that grows. They have a whole line of amazing hair growth products, including hair growth leave-in conditioner spray, hair growth shampoo, hair growth spray, and hair growth butter. I'm starting to sense a theme here. They include quality natural ingredients. They smell amazing, and you can see the results for yourself. So if you're looking for healthy hair growth for your natural or relaxed hair, try 12 Tribes on Earth today.
Ladies and gentlemen, many of us have been following the story of Daryl George, who has been suing for hair discrimination. And this story comes out of Texas, and I've done several videos on this. Well, it's now coming out that most Black students that sue over hair discrimination lose. And that's because they got the system rigged up for them to lose. So either you're going to enforce a Crown Act or stop giving the Crown Act altogether. That's the way I see it. So a federal judge has dismissed most of the claim in a lawsuit filed by a Black Texas high school student who alleged the school officials violated his civil rights by insisting he cut his hair to fit school policy. Daryl George battled with barbers, high school, and y'all, I remember when this story came out. It must have been now, what, about 2 years ago? So it began during the summer because they start school in Texas when it's still summer, when he faced numerous in school suspensions over his natural locks. School officials said George's locks fell below his eyebrows and earlobes, according to local media reports, which violates the district dress code for male students. George missed most of the regular classes in his junior year, spending the day in school suspension. He had to sit on a stool for 8 hours in a cubicle. Daryl's mother, this is what she said, and that's very uncomfortable. Every day he'd come home and said his back hurts because he had to sit on a stool. As a result, George and his mother sued the school district, superintendent, his principal, the assistant principal, as well as Texas Governor Greg Abbott and Attorney General Ken Paxton for violation of the state's Crown Act, which bans race based hair discrimination. George was initially suspended just a day before a Texas law went into effect statewide on September 1st. In the Tuesday ruling, U.S. District Judge Jeffrey Brown dismissed the claims against Abbott, Paxson, the school district, and school employees. Judge Brown, he also dismissed claims that enforcement was primarily being done against Black students, as well as the claim that Georgia's First Amendment rights had been violated as a result of the district policy. The judge said that the school had not shown a persistent, widespread practice of race based enforcement with its policy, but they said there was another student a year before him, and that was a Black student with locks, and the same thing happened to him. But you got to understand, these folks designed the system to work for them. They don't care if it don't work for us. That's why in all these centuries, they have never fixed things where it's more fair and balanced and it would work for everyone. They don't want that. Okay, they want it just for them. That's why it's called just us just us. And that's exactly what they carry out in these courts every single day across America. See, they give you the Crown Act and then at the same time tell you it's very difficult. And in most cases, Black students do not prevail in these cases, you know? So I guess everything that is given is always just for show. It does not have any real meaning or significance. And it's no intention of ever being enforced at all. It's just sitting there collecting dust. That's what the Crown Act is doing, just collecting dust. So when it came to the free speech claim, he determined that there were no precedented incident to demonstrate the hair length is supported under the First Amendment. However, George's claim of sex discrimination stood. In his ruling, Brown wrote that the rationale for the dress code distinction between male and female students, because the district did not provide any reason for S-based distinction in the dress code, the claim survives this initial stage. So that was the only thing he could get him on. Everything else the judge just threw aside about his hair. Brown acknowledged that the state's case had its issues, invoking a similar case in 1970, in which a judge concluded that the presence and enforcement of the haircut rule causes far more disruption of the classroom instructional process than the hair it seeks to prohibit. Mm-mm-mm. Well, you may say that, but you didn't do anything to really help the student at all. And this just goes to show you when you put the Crown Act up legally to be challenged, you still lose. You still lose. So, y'all, please tell me what you think about this story. Please leave your comment and subscribe. Don't forget to hit on the notification bell, and I'll see you on the next video. Peace, family.